Generally, unlike corporate directors, who can't waive the fiduciary duties they owe to shareholders, members of limited partnerships, or LPs, may agree to waive the fiduciary duties they owe to one another in a limited partnership agreement. But what about the implied covenant of good faith and fair dealing that exists in every contract? May this duty be waived in a limited partnership agreement? That was the question for the Delaware Supreme Court in Dieckman versus Regency General Partner LP. Regency Energy Partners LP, which we'll call Regency, was a publicly traded limited partnership. In addition, Regional General Partner LP, which we'll call the General Partner, was Regency's general partner. Further, Adrian Dieckman was one of Regency's limited partners. In Regency's LP agreement was a waiver clause that applied to conflicted transactions, which are transactions where the general partner has an interest that may be adverse to limited partners. The clause stated that an action taken by the general partner won't constitute a breach of the agreement of any fiduciary duties owed to limited partners under certain safe harbor provisions. These provisions included, first, approval by a majority of the members of an independent conflicts committee, and second, approval by a majority of unaffiliated Regency unit holders. In 2015, the General Partnership's board proposed a merger with Regency Energy Transfer Partners LP, which we'll call ETP. At the time, Regency and ETP were indirectly controlled by Energy Transfer Equity LP, who was the general partner of Sunoco LP. Consequently, the merger was a conflicted transaction, and Regency's LP agreement applied. The general partner appointed Richard Brannan, who was a member of Sunoco's board, to a two-person conflicts committee. Brannan then resigned from Sunoco's board. The general partner sent unaffiliated Regency unit holders a proxy statement describing the merger, as required by the LP agreement, but didn't disclose Brannan's conflicts. The conflicts committee and a majority of unaffiliated Regency unit holders approved the merger. Subsequently, Dieckman sued the general partner and others in Delaware Chancery Court, alleging breach of the partnership agreement. In response, the general partner moved to dismiss the action based on compliance with the safe harbor provisions. The court granted the motion, finding that the terms of the agreement displaced any implied contractual duty to disclose conflicts in the proxy statement. Dieckman appealed to the Delaware Supreme Court.